Good afternoon, Realtors. This is Byron King, South Carolina Association of Realtors in Columbia. It's November 16th, 2017. You can see my screen. I've got the award won last week at the NAR annual conference in Chicago by the 2017 Leadership SCR class, led by Mandy Chapman Crane and Kim Matthews and Jessica Pruitt. They won a video for the Roberts Rules of Order. This is on the Facebook page for South Carolina Association of Realtors. You can go on, click this link, or go to YouTube and watch it there. And then some of the staff involved: Austin wrote it, Sharon D'Elia was a videographer, Mike co-wrote it and did the editing, and then Jennifer Austin down here was also a videographer. So kudos to those folks for their award. And we got the lobbyist there and the rest of the team. So the lobbyist wants you to get involved with the Realtor Party. We've got some things going on in DC, Act Now on tax reform. That's at the NAR website, on the SC Realtors Facebook page as well, where you can take action on that call to action. Also, flood insurance cleared the House yesterday, but it's going to the Senate, so get involved to help make sure that stays on track. Otherwise, flood insurance expires at the beginning of December, so get involved. There's a Realtor Magazine article on the House passing the flood insurance yesterday. All right, so then we're going into our webinar. So this is the SC Realtors webinar page, our correction web page. You can look at all these web pages we're going to look at on your computer today if you want to, or come back and look at the video. It's being recorded. We've got the legal hotline. This is me and Austin. We do the legal hotline at SCR. You got the phone number 803-772-5206. You got our direct numbers here, 824-1971 and 807-2094. Got the legal FAQs right below our pictures. Thanks to Drew Street for spearheading that. We're talking about earnest money and wire fraud today. So we've got the earnest money dispute stuff, so you can file a magistrate interpleader and get that out of your account. Remember, it only comes out of your account with the party signing a disbursement agreement or a judge signs a disbursement order, and this tells you how to get the magistrate interpleader if you can't self-settle or mediate settle. Got the office policies that Austin generated, the long and short versions. And we're getting a lot of calls on do not call on the hotline about do not call. So make sure if you're calling those expired listings and withdrawn listings, you're checking the do not call registry and get up to speed on the do not call stuff on our web page. So that's good stuff. And so we're getting in. So zip forms, you can go to, this is on the screaltors.org page. You go to the forms. You can click here to see drafts of the upcoming forms. Liz Lodeholt, your 2017 forms chair, has a recorded webinar on the contract and one coming up December 14th on upcoming form changes. And you can also go there and you can see the actual rough drafts of the changes with the yellow highlights. You can see down here the 4 agency forms that the Forms Committee worked on August 30th and the minutes from that meeting if you want to review that and get up to speed. Those changes will be coming in 2018. But now we're getting into the main form here is wire fraud form here. And so wire fraud, the way this works is organized crime hacks into your realtor emails, hacks into a seller's email, hacks into a lawyer's email, hacks into a buyer's email, and sends fake wiring instructions. Well, they're not fake, they're criminal. So they send wiring instructions and the money gets routed to the organized criminals either in the United States or overseas. Main thing to remember for wire fraud is scare your clients to death, scare your lenders to death, scare law firms to death. A couple weeks ago, Greenwood Law Firm got hit for a wire fraud. Austin and I were in Chicago and heard about a North Carolina law firm that got hit for $750,000. The main thing is to contact the FBI immediately. So if you come up with any ideas that you might be a victim of wire fraud, contact the FBI immediately. So this form is useful. It's a one-page form, and this form is very useful for giving to all your consumers, giving to all your lenders, giving to all your lawyers, to all your paralegals, to make them aware. Hopefully everybody's aware, but as we saw last week, somebody got hit in South Carolina for wire fraud, so obviously the word still needs to get passed. So educate everybody about wire fraud. And the way the scam will work typically is the buyer will get an email that looks like it's from you, and it will tell the buyer to wire money to the law firm, and there'll be a false wiring instructions, and the money will go overseas. So main thing to remember about wire fraud is anybody can become a target for wire fraud crimes or assault. Always be suspicious of email wiring instructions. Always check the wire's authenticity and routing numbers. Immediately communicate any suspicion of an email wire fraud scheme to the banks and to law enforcement, specifically FBI. NAR has stated that if you can get in touch with FBI within 72 hours, there's a good chance that FBI may be able to recover that money. After 72 hours, your chances of recovering the money drop dramatically. And it says here, never wire money or send money to anyone without verbally verifying the wiring transfer directions and receipt via trusted sources, not the email, in a timely and reasonable manner. So make sure you recognize voices and people's faces, and keep in mind that the criminals can create false staff persons for false law firms and false phone numbers, even with South Carolina area codes 864-803-843. Due to wire fraud, realtors will almost never email wiring instructions. Always verify wiring instructions via trusted sources, not the email itself. Either using phone with somebody's voice you recognize, visual, you see them in person, or you Skype with them, or use the U.S. mail or a fax machine. And you want to use law firms and professionals that are local, that you know and trust, so you can become comfortable, recognize his voices and faces. And again, beware, criminals create fake law firm staff, fake law firm phone numbers that can even be local area codes. Domestic and overseas wire fraud criminals can create fake phone numbers using a local area code. Domestic and overseas organized wire fraud criminals may hack into email accounts, the lawyers, the sellers, the real estate licensees, the bankers, and email fake wiring instructions to you and steal your money if you wire without verification. You probably also want to give this form to your financial staff. There's also a scam where it looks like an email from the boss telling the financial staff to transfer money, and that transfer is false, transfer instructions, sending the money to organized crime criminals overseas. Wire fraud defenses: proper verification of all wiring instructions. Use secure or encrypted email. Use the U.S. Postal Service. Use a courier service. Use fax machines in lieu of email. Email is vulnerable to wire fraud hacking. Obtain cyber and crime insurance. Utilize trusted realtors. Utilize trusted local established professionals. Timely investigate and check on people, companies, and real estate schemes and crimes. The internet to avoid and deter crooks. Contact law enforcement and SCR for information on wire fraud. Domestic and overseas criminals will fish for your identity theft information. Beware of clicking links on emails. Consider using an email authentication text code alongside state-of-the-art password protection. Sellers should secure all valuables, drugs, weapons, pets, sentimental items, and identity theft information prior to showing. Consider personal safety at all times. Criminals scrape listings into fake rentals. That's the other scam, so use Google Alerts with your listing addresses and alert Craigslist and vacation rental by owner as soon as you see some of those listings being put on as fake rentals on the internet. And then the usual warning, parties should talk to their lawyers before the contract, during the transaction. Realtors recommend obtaining legal counsel, verify wiring instructions. Due to potential wire fraud, parties are solely responsible to verify all wiring instructions from anyone. Parties acknowledge receiving, reading, and understanding this wire fraud warning. Please report crimes to law enforcement, that's the FBI, and do that within 72 hours to maximize your chance of recovery. Try to do it as soon as possible if you get any idea that you may be wire fraud involved in your transaction. And you got 3 blanks, so you can have consumers sign this, you can have all your brokerage staff sign this, your licensees, your employees, your financial staff. Law firms that you use, you probably want to hand this out to the lawyers and their staff and make sure they all sign it just to get the word out, and then you can initial down at the bottom. And if you want to learn more, you can go online and just Google Realtor wire fraud. You can see there's plenty of articles. If you don't like reading, there's plenty of videos from NAR and other associations around the country. South Carolina Association has our YouTube site. You can go there and you can see Linda Huberman O'Neill talk about her wire fraud scenario. Luckily, they were able to recover over $200,000 in her scenario. You can see me in Austin as Pirates talking about the scams. And then again, you go into our forms and you can pull up, this is the forms page. If you want to get the wire fraud, you just click on it. It's got all our forms, or you can go into your Zip Forms account, just click wire fraud, submit, and the form will pop up. and you can print it, and it's in your zip form, so you can email this to everybody, carry these around, hand them out to everybody. All right, changing gears to Earnest Money. Earnest Money, we've got a new form, the Earnest Money Disclosure Form. It's very short and sweet, Form 620. This was designed by the executive committee, and some folks say, hey, Byron, isn't that already in our contracts? Yes, this is the base residential contracts. If you go to Section 5, Earnest Money. Sorry about that. You can see in this section here, it basically says, hey, the parties understand that under all circumstances, including default, the escrow agent will not disperse earnest money to either party until both parties have executed an agreement authorizing disbursement, such as SCR 518 release, SCR 517 disbursement agreement, or a mediation agreement, or until a court of competent jurisdiction is directed to disbursement. Earnest money will not be dispersed until determined to be good funds, so you got to make sure the check doesn't bounce. If legal actions occur related to earnest money, the party receiving the least amount of earnest money in the court's disbursement order agree to indemnify the escrow agent's fees, court costs, and attorney's fees. If interpleters be utilized, parties agree that fill in the blank shall be paid to the escrow agent by the parties as compensation before escrow agent initiates court of competent jurisdiction proceedings on earnest money. If it's less than $7,500, you go to magistrate interpleader. Only the broker holding the earnest money can file a magistrate interpleader. That's going to cost you a little over $100 to file. If it's more than $7,500, you're talking about going into circuit court. So that's lawyer fees and a lot of time involved. So that dollar might be larger depending on the amount of earnest money. But the executive committee said, hey, we want a simple form, because when people call to complain to us, why is my money still in your trust account? It's very handy to hand this form to them and say, hey, you remember you signed this form at the beginning of the transaction. So this is a new form. Probably want to print these out, email them, hand them out to your consumers, get everybody to sign it. And it basically restates what we just talked about. So it's earnest money disclosure. It says the parties understand that sometimes, unfortunately, a transaction may fail to close for a variety of reasons. Parties understand the broker in charge holding the earnest money deposit must handle the earnest money deposit in accordance with South Carolina real estate license law, paraphrased below. Buyers and sellers agree that if a transaction fails to close, a broker in charge acting as an escrow agent shall hold the earnest money in safekeeping in accordance with South Carolina laws and shall not disperse the earnest money until all the buyers and sellers sign a disbursement agreement stating who gets what amount of earnest money. That could be 518, the release, 517, the disbursement, or the mediation agreement. Or a court of competent jurisdiction issues a disbursement order. That could be a magistrate. If the broker in charge holding the money files a magistrate interpleader, that's a voluntary legal action not required. You can still hold the money indefinitely in your trust account. And then if it's over $7,500, you're in big court. Only when all parties sign a disbursement agreement or a disbursement order is obtained from the court, the broker in charge will properly disperse the earnest money within a reasonable amount of time in accordance with South Carolina laws. If parties are using lawyers to hold their earnest money in trust, this is becoming more common based on hotline calls, the parties should consider getting a written escrow agreement signed with that law firm that details how the earnest money is held and how the earnest money is dispersed by the lawyer. Austin and I are even getting calls from law firms that don't know how to. They're like, hey, Byron, what do we do? We've got this deal fell through. We're holding $1,000 of these parties' earnest money. And I say, hey, it'd be ideal if you had an escrow agreement when that money went in and said how the money's coming out. Otherwise, you know, that's your issue to handle. And of course, buyers and sellers are encouraged to obtain legal counsel prior to signing any document. You get them to sign this, put it in the file, and then you get them to sign, when they sign the contract, there's going to be stuff in here about the earnest money, restating what we talked about. You got to have a release, you got to have a disbursement agreement or a mediation agreement, or you got to get a court order. All right, and this is all based on Article 8 of the Code of Ethics. Talks about, sorry, let me scroll down. There it is. So Article 8 of the Code of Ethics says realtors shall keep in a special account in an appropriate financial institution separated from their own funds, money coming into their possession in trust for other persons such as escrows, trust funds, clients' monies, and other like items. So if a law firm is going to hold the earnest money, you'd probably not want to take possession of it. You probably just want to say, hey, buyer, get that check for $1,000 to ABC law firm or whoever you're dealing with. And if you want to read the law itself, this is the scstatehouse.gov. You can go there and you can look up bills. You can look up code of laws. You can read about the Senate and House. This is the section here. This is an important section here. It's 40-57-136. This is your trust account language in here. There's some new language in here this year. It talks about if a licensee receives trust funds, they get, so you got an associated licensee that gets a check. They've got to get that check to their broker in charge no later than the following business day. And then obviously the broker in charge is under the old rules where if it's cash, you got 48 hours to deposit, excluding Saturday or Sunday. If it's a check, you can even hold it up to 48 hours after the contract is signed. Those are the broker in charge rules. So for everybody else, if you get a check, that check's got to be at your broker in charge's office the following business day or at the law firm the following business day. And that was mainly because checks were getting lost. So. And then the law talks about if a dispute arises, it talks about and the dispute is not resolved by reasonable interpretation of the contract by the parties, the deposit held in trust, and the dispute basically is settled by signing a mediation agreement, signing a 518 release, or signing a 517 disbursement agreement, or a judge signs an order saying, hey, who gets the earnest money? And they're back on our forms page again, and so that covers that. So if you wanted to look up this form, you would just go down here and look up, select your form, and scroll all the way down to Earnest Money Disclosures Form 620, and you can do this in zip form as well. That's how you get to the form. And so that covers that. We get any questions on earnest money or wire fraud? All right, so we'll keep pressing on. We're kind of tricking you a little bit. We're getting into, we've got a professional standards update. So we baited you in, bait and switch a little bit. We give you some wire fraud and earnest money, and now we're going to go into a code of ethics review. This is our annual webinar. It can be used for stragglers that want to make up for some training on professional standards. So you can always go to NAR.Realtor. This is their homepage for the Code of Ethics. You can read through that. Lots of good information. And if you want to take some online training, there's free courses you can take. There's for new members, for existing members. And the training requirement, this is NAR has doubled your ethics training. So it was every 4 years, now it's every 2 years. So realtors are required to complete ethics training not less than 2 hours, 30 minutes of instruction time within 2-year cycles. So the next cycle, we're already in it. So everybody's got to get 2.5 hours of ethics no later than New Year's Eve 2018. So this is a doubling of your ethics requirement. It was every 4 years, and now it's every 2 years. For everybody that's serving on our Professional Standards Committee, Grievance Committee, or mediators, we want you to take this training every year so you stay up to speed on the Code of Ethics. And for people that want to file a complaint on realtors, you can go to screaltors.org. You go under Find a Realtor, you click File a Complaint. This goes through how to file an ethics complaint. We do the professional standards for state, except for Charleston, Columbia, and Greenville. If you want to file a complaint on lenders for mortgage fraud, you got the FBI phone number. For discrimination, you can file a complaint with HUD or South Carolina Human Affairs Commission. License law violations, you can file a complaint with the Real Estate Commission. And then for unethical professional conduct, you can call us for the realtors, except in those 3 cities mentioned earlier. For the lawyers, that's the phone number to file a complaint against lawyers. There's the phone number to file a complaint against mortgage brokers. Also under Find a Realtor, you can look up Code of Ethics. So that gives you can get information, you can download the Code of Ethics. For mediation, if you want to mediate, an earnest money dispute or any kind of dispute, you can go here. It's got the list of mediators. There's the mediation brochure. You click there. And there's a good explanation of mediation. It's also got our statewide list of mediators that the parties or the brokerage and the parties can contact and hire a mediator to help settle the dispute. And that's got the list here. And then if you want to become a mediator, we'll have mediation training coming up in 2018. This is the mediator applications also on this page. But mediation is very good for earnest money disputes or any kind of dispute, because what you want to do is try to settle things and not go to court, settle things, not have an ethics violation filed against you, settle things, not have a license law filed against you. All right, then we're back on the Realtor, NAR.Realtor website. This is their home page for the Code of Ethics video training. So if you don't like to read, again, there's plenty of videos on here. You can go through the entire Code of Ethics. Every article, 1 through 17, is a video. There's other resources on YouTube by NAR and other local boards that goes through the Code of Ethics, so you can go outside of this webinar and learn stuff. And if you want to take online training, there's the, like we talked about earlier, there's the online course. You can get CE. You can take a free course to get your 2.5 hours by New Year's Eve 2018. New members can take the class. You can take the online class just to refresh your memory about the Code of Ethics. All right, then we'll just go through the Code of Ethics. So this is the part that's going to take a while. Get all the way back to the top. All right, so the Code of Ethics, you can download the Code of Ethics. We're at the NAR.Realtor. That's their home website with their new domain. You can pull up translations into different languages, and you can see how it's organized here. It's got Articles 1 through 9 are your duties to your clients and your customers. Articles 10 through 14, your duties to the public. And then Articles 15 through 17 are your duty to other realtors. So the preamble, this is basically setting up saying that it's very important for the industry to have a code of ethics, to treat others as you would like to be treated, the golden rule. So you follow that, that should keep you out of trouble most times. But Article 1, that's the first one. So it says, when representing a buyer, seller, landlord, tenant, or other client as an agent, realtors pledge to protect themselves, to protect and promote the interests of their client. This obligation of the client is primary, but does not relieve realtors of their obligation to treat all parties honestly when serving a buyer, seller, landlord, or tenant, or other party in a non-agency capacity. Realtors remain obligated to treat all parties honestly. So never tell a lie. You can diplomatically refuse to answer, but you cannot lie to people, and you should promote the interest of your client. And in between are standards of practice. So you can go back and read these at this website, but they basically reinforce Article 1. And so what we do when we get a complaint from a member of the public, the member of the complaint can write in the Article 1, and then if, say, Article 1 is standard of practice 110 may apply, they can add that in. That would go in front of the grievance committee. We do that by conference call with 3 to 5 members of the grievance committee. They look at the complaint and decide if everything in that complaint is assumed to be true. Does it fit into one of the 17 articles that we're going to go over? Is it against a realtor member? Was it filed within the basic statute of limitations, the 180 days of discovering the issue in a reasonable manner? And if so, it's forwarded to a hearing. Hearings are held here in Columbia in front of 5 hearing panel members generally with board counsel, and the members come in to face their accuser, either another realtor or a member of the public. Both sides are allowed due process to make opening statements and then present their case and their defense, cross-examine their accuser, cross-examine witnesses, examine documents, present witnesses and documents and testimony in their behalf, and then they both make their closing statements. And then the hearing panel adjourns and it sends them and goes into executive session where the parties leave the building and then decide if there's a violation of ethics. If no violation, that's the end of it. If a violation is found, then they will assign punishment. Typically, this discipline is either a fine, an admin fee, and some education. But there are more serious sanctions available, and repeat offenses or more serious offenses can rise to even suspension of membership for a while. Also, we've adopted the NAR citation policy. So for certain quote-unquote minor offenses, prior to the hearing, the defendant, the respondent, is given the ability to just pay a set fine and a set amount of education and avoid the hearing. So that's the other option for that. So we're in Article 2. Article 2 says, realtors shall avoid exaggeration, misrepresentation, or concealment of pertinent facts relating to the property or the transaction. Realtors shall not, however, be obligated to discover latent defects in the property, to advise on matters outside the scope of their real estate license or to disclose facts which are confidential under the scope of agency or non-agency, which is transaction brokerage relationships as defined by state law. And again, there's standards of practice for Article 2 as well. Article 3, realtors shall cooperate with other brokers except when cooperation is not in the client's best interest. The obligation to cooperate does not include the obligation to share commissions, fees, or to otherwise compensate another broker. And again, you got the standards of practice that can further highlight the article. All right, and then Article 4, we've got realtors shall not acquire an interest in or buy or present offers from themselves, any member of their immediate families, their firms, or any member thereof, or any entities in which they have an ownership interest, any real property without making their true position known to the owner or the owner's agent or broker. In selling property they own or in which they have an interest, realtors shall reveal their ownership or interest in writing to the purchaser or the purchaser's representative. And Austin's back from DNR, so what we'll do, we'll go through all 17 of those. I'm going to give Austin a short, Austin just got back from the NAR legal briefing, and he can give you an update direct from NAR on any hot legal issues here. So we're about a third of the way through, so Austin's going to be working on that while we're going through these. Article 5, realtors shall not undertake to provide professional services concerning a property or its value when they have a present or contemplated interest unless such interest is specifically disclosed to all affected parties. You can see Article 5, there are no standards of practice for Article 5. Get any questions so far? All right, no questions, good. Article 6, realtors shall not accept any commission, rebate, or profit or expenditures made for their client without their client's knowledge and consent. When recommending real estate products or services such as homeowners insurance, warranty programs, mortgage financing, title insurance, etc., realtor shall disclose to the client or customer to whom the recommendation is made any financial benefits or fees other than real estate referral fees the realtor or realtor's firm may receive as a direct result of such recommendation. So typically your closing disclosure is going to have some of this information. It's going to have your commissions, your compensation on there. The contract actually has a line, you know, alerting the consumers that you may be getting some of these amounts, but you probably want to double down on that and give written confirmation of the amounts you're getting for any kind of referrals or any kind of relationship you have with another company. So there's only one standard practice for standard practice 6-1, so we'll go ahead and cover that since there's only one. Realtors shall not recommend or suggest to a client or customer the use of services other than an organization or business entity in which they have a direct interest without disclosing such interest at the time of the recommendation or suggestion. And this is a big one. This is the one, if you go and look at the Federal Consumer Financial Protection Bureau, this is the one that enforced RESPA against some large brokerages around the country with some significant million-dollar fines. So make sure you disclose. All right, Article 7, in a transaction, realtors shall not accept compensation from more than one party, even if permitted by law, without disclosure to all parties and the informed consent of the realtor's client or clients. Article 8, we covered this earlier when we talked about the Earnest Money Disclosure Form. So realtors shall keep in a special account in an appropriate financial institution separated from their own funds monies coming into their possession in trust for other persons such as escrows, trust funds, clients' money, and other like items. All right, and this is the one where zip forms comes in. When you have zip forms member benefit, it talks about get it in writing, right? Everything needs to be in writing. Be careful about using text messages. Austin and I get a lot of hotline calls where realtors are skirting the edges of professionalism, you know, using text messages to negotiate contracts. Make sure you're using the actual forms themselves, or you're using your zip forms or something very similar, not using text messages. Article 9 says realtors, for the protection of all parties, shall assure whenever possible that all agreements related to the real estate transaction, including but not limited to listing and representation agreements, purchase contracts, and leases, are in writing in clear and understandable language expressing the specific terms, conditions, obligations, and commitments of the parties. A copy of each agreement shall be furnished to each party to such agreements upon their signing or initialing. So you got zip forms mobile now. So basically, if you have a smartphone on you with the zip forms app, or with internet access, you're able to email documents. You can send the copies. You can comply with Article 9 with ease at all times. Zip Form Mobile, also one of your member benefits, where your clients and consumers can actually just sign right there on your smartphone with a fingertip. And you can see there's 2 standards of practice for Article 9, so let's cover those. Standard Practice 9.1. For the protection of all parties, realtors shall use reasonable care to ensure that documents pertaining to the purchase, sale, and lease of real estate are kept current through the use of written extensions or amendments. So we've got SCR 390. If you're in Zip Forms, a lot of times on the hotline we get calls, hey, it's got Amendment 1, 2, 3, and 4. What are those? Those are all duplicate Form 390s, just so you have additional forms already ready to go. Standard Practice 9-2, when assisting or enabling a client or customer in establishing a contractual relationship, such as listing and buyer representation agreements, purchase agreements, leases, etc., electronically, realtors shall make reasonable efforts to explain the nature and disclose the specific terms of the contractual relationship being established prior to be agreed to by a contracting party. So when you give the buyer agency agreement, when you give the listing agreement, explain these are serious legal documents. A lot of times we get calls, we get arbitrations. 9 out of 10 arbitrations are because buyer agents did not explain to the buyer, hey, you're signing an exclusive right to buy buyer agency agreement. You are not to go to model homes. You are not to go to builders. You're not to go to for sale by owners. You're not to talk to other realtors. Everything you do about buying a house in this price range in this area goes through me, your realtor. If you don't do that, I can sue you for breach of contract of the buyer agency agreement plus my attorney's fees. So buyers claim, I didn't even know I signed one of those buyer's rep agreements, or they don't know how serious they are, and then the buyer goes and talks to another buyer brokerage or to an open house or to a model home or to a for sale by owner, and then we end up getting arbitration when the 2 buyer brokerages are arguing about who's procuring cause of the transaction. So make sure you explain the buyer rep agreement to those buyers. Article 10, duties to the public. So you see the first one here is this is basically your fair housing article. So it says realtors shall not deny equal professional services to any persons for reason of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Realtors shall not be parties to any plan or agreement to discriminate against a person or persons on the basis of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Realtors in their real estate practices shall not discriminate against any person or persons on the basis of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, gender identity. The new hot topic is service animals, emotional support animals, comfort animals. We have a webinar that Mike Chris produced with the South Carolina Human Affairs Commission staff are talking about comfort animals, so that's a big deal. Also, I just saw a couple cases around the country that should give us a better picture of these things. These are the, some of them may be legit, where you've got, somebody returns from a veteran, returns from Afghanistan, needs a comfort animal to keep their stress level, their post-traumatic stress disorder under control. Other people see these are abuse type deals, trying to run a no pets clause or a pet rent or a pet deposit. And so right now our recommendation is if you're dealing with a comfort animal, you basically allow it. If the landlord wants to fight it, then you recommend they hire a law firm and get in touch with us. Maybe the legal action committee members would be interested with supporting either through an amicus brief or some sort of financial funding for that lawsuit. But right now our recommendation is the risk is so high that you basically allow it. You can still charge damages even if it's a service dog, a CNI dog. If they tear something up in the apartment, you can still deduct. But otherwise, service animals, emotional support animals, comfort animals, therapy animals, you do not charge pet rent, pet deposits, and you allow those animals even if there's a no pet clause. The idea being they are not pets. They are something other than a pet. And you can see there's a couple standards of practice, 3, 4 standards of practice for Article 10. Article 11 is the services. This is basically saying you're going to do what a reasonable professional realtor would do. So the services which realtors provide to their clients and customers shall conform to the standards of practice and competence which are reasonably expected in the specific real estate disciplines in which they engage, specifically residential real estate brokerage, real property management, commercial and industrial real estate, brokerage, land brokerage, real estate appraisal, real estate counseling, real estate syndication, real estate auction, international real estate. So if you don't know what you're doing, you've never done one of these deals before, you need to learn real fast or associate with a realtor that has done one of these until you get up to speed. Realtors shall not undertake to provide specialized professional services concerning a type of property or service that is outside their field of competence unless they engage the assistance of one who is competent on such types of property or service, or unless the facts are fully disclosed to the client. You basically say, I don't know what I'm doing, so that's not a good idea. So you'd want to either learn how to do it or associate with somebody that knows how to do it and keeps you straight. Any persons engaged to provide such assistance shall be so identified to the client, and their contribution to the assignment should be set forth. And again, some standards of practice. All right, Article 12, one of our top ethics complaint sections. This is basically your communications and advertising code of ethics. Realtors shall be honest and truthful in their real estate communications and shall present a true picture in their advertising, marketing, or other representations. Realtors shall ensure that their status as real estate professionals is readily apparent in their advertising, marketing, and other representations, and that the recipients of all real estate related communications are or have been notified that those communications are from a real estate professional. So we talked about the do not call list. So if you're making phone calls, make sure you're checking do not call registry. You also need to have a brokerage do not call registry in case another licensee in your agency has been told do not call this number again. We're getting a lot of complaints. A listing gets expired or withdrawn, and the sellers immediately get inundated with calls starting at 7 o'clock in the morning, running till midnight. These owners call us complaining, say my teenage daughter's getting calls, my mother-in-law is getting calls, they're calling me up at midnight. I'm getting like 50 of these calls a day. I tell them not to call. I'm on the do not call registry, and eventually the consumer will get mad and file a complaint on you. So you be very careful with this stuff. And then the other thing is canned spam for email. So any email that's an advertisement, you have to disclose this is an advertisement and give the receiver a free way to opt out. And then once somebody opts out of getting calls or emails, you've got to honor that. Or you're going to be answering the federal government. And you got lots of standards of practice for 12. Article 12 is one of our top complaint articles, and it's typically from advertising. All right, and then Article 13, that's your CEO, Nick Cremitis, General Counsel Byron King, Staff Attorney Austin Smallwood, we're all attorneys, so this is our favorite article. It says, realtors shall not engage in activities that constitute the unauthorized practice of law and shall recommend that legal counsel be obtained when the interest of any party of the transaction requires it. So do not practice law without a license. It's a felony crime in South Carolina. It's an ethics violation under Article 13, license law violation. You have standard forms. You're authorized to fill in the blanks, you know, with names and numbers and addresses and items. But you're not supposed to be writing sentences or phrases into those blanks. Just because the blanks are long does not mean you should be writing sentences or phrases that are not legal, not reviewed by lawyers. So make sure you call the hotline 803-772-5206 if you have any questions about any kind of legal issues or filling in the forms. And we've also got a lot of webinars. Mike Chris has produced a lot of webinars. Liz Lodeholt, our forms chair for 2017, is the #1 video with over 4,000 views. And again, she's going to be on here doing a webinar on forms December 14th. Article 14, this is how you know, the associations get realtors to show up for hearings because you have to. It's under the Code of Ethics. If charged with an unethical practice or asked to present evidence or to cooperate in any other way, such as a witness, in any professional standards proceeding or investigation, realtors shall place all pertinent facts before the proper tribunals of the member board or affiliate institute, society, or council in which membership is held, and shall take no action to disrupt or obstruct such processes. So that's basically your, you know, you participate in ethics hearings and you participate in arbitrations. We're getting a lot of these. Article 15, this is the one where it says realtors shall not knowingly or recklessly make false or misleading statements about other real estate professionals. So real estate professionals could be realtors, could be real estate lenders, real estate closing attorneys, inspectors, you know, the whole gamut. Their business or their business practices. So a lot of people like this, you know, in our classes, when Austin and I give these roadshow classes, we're getting ready to go back on the road across the state for 2018. So if you're a local board and you want to set one of those up, contact me in Austin. But people always snicker and say, hey, Byron, what if it's true? So truth is a defense, but obviously people might argue about if something's true or not. So the safe thing is, just like you've heard from your grandmother, you can't not say anything nice about somebody, then don't say anything at all. And this applies to talking, this applies to emails, this applies to social media. So just be careful. We get a lot of calls about that one. All right, Article 16 is the other one we get a lot of complaints about. This is basically, I call it poaching other people's clients. So realtors shall not engage in any practice or take any action inconsistent with the exclusive representation or exclusive brokerage relationship agreements that other realtors have with clients. So you get somebody come in your office, they want to write an offer on a house that day. It's probably a good idea to ask them, hey, have you been looking at houses? If they say yes, have you been out looking at houses with other realtors, and read their body language, read their their eyes, how their tone of voice, try to detect any kind of inconsistencies, and try to dig a little bit, asking some questions, because it'd be unusual for a buyer just to show up to your office and want to write an offer that day for a property. So make sure there's not another realtor involved, otherwise you could be facing a complaint under Article 16. And we're getting to the last one, and so Article 17 is basically Article 14 is how we get people to come in and do ethics and arbitrations. Article 17 is commission disputes. So Article 17 is your arbitration. It basically talks about arbitration, and the main way we see arbitration is property is listed, buyer brokerage one has a buyer, the buyer basically goes and looks at houses with this brokerage, with the agent working for that brokerage, and then the day they want to write their offer, they go to another realtor. The other realtor either asks or doesn't ask if they've been working with somebody, and they either ignores the answer or doesn't follow up and dig down with some questions. And then there's a dispute between the two brokerages about procuring costs. So Article 17 is how we get them into arbitration. And then it goes through the grievance committee, just like we talked about ethics. Hey, is this between Realtor Brokerage A versus Realtor Brokerage B? Is it based on the MLS or some sort of compensation agreement or referral agreement? There's got to be a contractual dispute. And then was it filed within 180 days of closing, depending on when they reasonably could have discovered the closing occurred. And then the grievance committee would send it to a hearing, 5 realtors here in Columbia, except for the 3 boards that do their own. And then you have opening statements, present your case, due process, cross-examine, present evidence in your defense, closing statements, and then the 5 arbiters will award the arbitration amount to one side or the other. And then there's some standards of practice there. All right, and then getting ready to let Austin come in and give you a quick update from NAR with his visit with NAR, their legal meetings. There's a current offer if you take action. NAR, if you do some things, they will give you different, basically freebies from their electronic store. This one that just came in today, you can get free books at the NAR library. All right, then Austin, come on up and give the folks a quick briefing on NAR legal issues that you heard about last week. Thanks.
Okay, thank you, Byron. As Byron said, I went to the NAR annual meeting last week in Chicago, and we actually had a briefing from 3 FBI agents, and mostly regarding wire fraud. That was the overwhelming topic at our event, and they had a few facts or piece of advice that I hadn't heard before, so I wanted to kind of relay those to you. They said if you are involved or have a client involved in a wire scam, you essentially have 72 hours for them to have any chance of fixing it. But really, you need to let the FBI know within 42 hours. Or they can do something in 72 hours, but you really need to let them know in 42 hours so they can have 30 hours to fix it. Once it's been more than 72 hours, there's really not a whole lot of chance of getting the funds back. They obviously said make sure that if you don't know an attachment or aren't aware if it's from a mysterious email, don't click attachments. And don't send them to someone else in your office to say, hey, I can't open this, do it that way. if you get an email from somebody you're not familiar with, the best thing they recommended was instead of hitting reply to hit forward, because when you hit forward, it will actually expose the real email address. And a lot of times they're trying to copy an email address similar, but if you hit forward, then you physically have to type in the email address, and that will let you know whether or not that was a spam email. They also suggested that you delete your sent folder and your spam folder and your deleted message folders on a fairly regular basis, because if you are hacked, the hackers will actually sit in your email account and read everything, and the less information you provide them, the less ability they have to copy the way you think and things of that sort. And also that they are monitoring your Facebook, and they were talking about how they would have copied clients or agents to say, hey, as you know, I'm on vacation, so also be very mindful of what you're putting, what kind of public information you're putting out there on Facebook. The other real legal issues they brought up were stuff regarding ADA, and once again making sure that your website is compatible with that, and there's some information on the NAR website, or you can call Byron or myself if you have any of that. And then also to be very careful when showing property, to be very careful of that stuff, especially with this emotional support or service animals. In regards to ethics, really the only things that they really said were that they're really doing a good job nationally to try to increase the ability of people to testify either remotely or different ways. But we really can't find, Byron and myself aren't out there looking for ethics violations. So the only way we really know about it is if people file the complaints. And NAR has really gone out of their way to try to make it easier for people to file and people to testify. But if we don't know about the complaint, then there's nothing we can do about it. And also they said Article 12 is kind of the one that's growing nationally. That's really getting into your advertising, and in particular what you put out there on social media, that social media is the equivalent of a mailer or a sign. So be very mindful of what you're putting out there on social media.
Also, give them a heads up about the Real Estate Commission yesterday.
Yeah, so I was at the Real Estate Commission yesterday, and they did elections for new officers, and Candace Pratt from Somerville was elected chair, and Andy Lee from the Western Upstate area was elected vice chair. David Kriegler had been chair for the past 3 years and decided that let a new voice get on there. He will still serve on the commission, but Candace Pratt is the new chair and Andy Lee is the new vice chair.
Great, thanks, Austin. We had one question asking about the NAR giveaway, so let's go back to that website. You should have gotten an email on your inbox from NAR today, but as you can see, it's the mvp.realtor.org. So just go to mvp.realtor.org. If you remember, the NAR started doing this during the recession to help realtors, because they sell a lot of stuff on their e-website, information on, the last one I saw, if you did a survey, you would get like a profile of buyers that they compile with surveys. But this one that I read today, you're allowed to basically check out ebooks, and they're books on real estate, obviously, so that's something you can do, and take advantage of your member benefits at mvp.realtor.org. And again, thanks to Mike Christ there on the bottom left for producing, and congratulations to where'd it go? There it is. Mike was the editor, Austin was the writer, to all the actors from SCR Leadership, the leadership class leaders, Mandy Chapman-Crane and Kim Matthews, who really promoted doing a video on Robert's Rules of Order. The class read a book on Robert's Rules of Order and did a great video. Won an award at the NAR meetings, so that was fantastic. And we'll keep up the good work. Thanks for tuning in.
All right, if anyone wants to rewatch this webinar, it will be located on our webinar archives. You can go to scurealtors.org/webinar-archive. And if you go there, Austin had mentioned the accessibility with websites. We do have a webinar on that, and we also do have one about service animals, so make sure you check out those. If you go to that website, it will be a list of all of our webinars in chronological order. And with that, I think we're okay. Thanks for tuning in today, and we'll see you in the next webinar.